While the factors narrow tailoring the consideration of the reasonable alternatives and adequate findings, those factors are absent here. Hold up. Let me take this. Yeah. Okay. One, these are the four. One, there must be an overriding interest that is likely to be harmed if the proceeding remains open. Two, the closure must be no broader than necessary to protect that interest. Three, the judge must consider reasonable alternatives to closing the courtroom. And four, the judge must make specific findings on the record explaining why the closure was necessary, which he never did. There was no explanation for why the closures were even made at all, right? And even if you went through the electronic files trying to go and figure out if you could make a filing or make a complaint, there wasn't no feature there for you to even make that formal complaint. Okay. So some of these Waller factors were broken. Okay, cool. Or not adhered to, at least, right? These decisions do not create a mechanical rule that a live feed is always required or always sufficient. They make a narrower point. When seating limits predictably exclude the public, the trial court must consider practical alternatives: reserved public seating, a larger courtroom, staggered admission, an overflow room, or an audio or a video feed, and must make findings explaining why any rejected alternative is inadequate here. The court used an overflow room alternative during jury selection and then withdrew it when testimony began. So they show you the Waller v. Georgia. Waller is the case that they keep citing. It's called Waller versus Georgia, US 1984, the time it happened, right? No, the entire suppression hearing was closed with no alternative offered. The outcome, the closure was unjustified. New suppression hearing was ordered. Okay. Stedman, in the Stedman versus the state, right? No, it's an overflow room or live remote feed available. So that's the no that we're saying no to. Okay. Family barred from voir dire for lack of rooms or alternative not considered. The outcome, the structural error conviction reversed and a new trial was ordered. So some people saying that he doesn't have a lot of grounds for a new trial, but he actually does. He has a lot of grounds for a new trial. I just think that this case was shoddy from the very beginning. And I just believe that even his own defense agreed to things that they should have never agreed to. Even when the witnesses came on the stand, they wasn't had no pushback. All of these things were spoken about. How the victim, they said that all of the witness, not victim, the witnesses came off the stand without contest. They didn't go into the alleged bullying that the twins were being and doing. They didn't go into the history of the twins, how they could blow up and how they could get aggravated at a time. All of these specific things, just like in the introduction of this video, it shows that it's going to the history and the patterns of both brothers, Austin and Hunter. RIP to Austin, you know what I'm saying? Straight, man. He's a kid. I don't think that he should be dead right now. And I don't think that Karmelo should be serving 35, but we just gotta call a spade a spade. I don't believe that that prosecution wanted to go into the past of those boys and the past of Karmelo, because you would have seen that his past was not speckled like those boys were. Sometimes we just see faces like this and you just presume that a person's a King Vaughn and a person's like that. Not everybody's like that. Doesn't matter what color you are, okay? Just remember what I'm telling you when it comes to that. All right, cool. Let's go down. Lilly versus the state. As far as the courtrooms and the live feeds and all of those things, no to all of those, right? No. So a trial conducted in a restricted access setting, some similar to Karmelo. Structural error, new trial. Presley versus Georgia in 2010, no to that answer as well. Reserve rows, overflow room wasn't even considered in that. What happened? Reversed. Trial court must consider reasonable alternatives, period. William versus State, yes. Live feed to a neighboring courtroom. But what happened? The outcome, a trivial closure, no violation. Zorns versus Bolin. Yes, a remote viewing from an observation room. So they actually had an observation room in this case, like set up like an overflow type of room. Trivial closure with no violation. In this case, provide none. Provided only during jury selection, then withdrawn for the testimony, no fee thereafter. So what's the outcome? Falls on the Waller, Stedman, and Lilly side of the line. So they gave you cases that they actually had feeds or made some kind of accommodations to the public and to everyone else. And then they cited their first cases, which they're standing on and using for their own defense, which is Waller, Stedman, and Lilly. Those three cases. Cool. This case sits on the wrong side of that line, and uniquely so. The court did not merely fail to provide an alternative, it provided one during jury selection. So you actually did it before, and then you pulled the rug. So it's not like you never did it, and then you said, you know what? We don't need to have an overflow room. We're just going to do it just like this from the very beginning, because this is how we're going to maintain privacy, and this is how we're going to maintain misinformation and all these different things with this trial. No, you actually provided one at first, and then you pulled it back with no response, no answers, or nothing to say to nobody. See what I'm saying? So that's the problem that Karmelo's defense team is having. During jury selection, a live feed to an overflow room, and then switch it off for the testimonial phases. The most consequential part of the trial, a court that has shown it can pipe the proceedings to an overflow room and then darkens the feed when the witnesses take the stand, has not taken every reasonable measure to accommodate the public attendance. And as the public, our tax-paying dollars makes everything run. It is our constitutional right to be in the trial. They cannot stop us from being there, okay? We are there as members of the public. This is how you make sure that people get fair trials. Remember, this is how it goes, okay? So we can't be there. Why? Think about that. It had done actually the opposite. Critically, the closure was imposed by the court on its own motion. No party moved to close the courtroom or to restrict the public access. The court entered the amended order. They amended order, conducted to no evidentiary hearings, and received no evidence in support of any offered to justify the restrictions. Now, the defendant was not afforded a pre-ordered hearing or an opportunity to be heard before the access regime was imposed. And the written order did not disclose the facts that made the closure apparent in operation. The actual allocation of public and family seats, the defense family limitation, the withdrawal of the overflow room when testimony began, the denial of the alternate access, or the off-record administration of the public line. D, in actual operation, public access was even more restricted than the order's text provided. The deficiencies in the order's text were compounded by the way the access regime operated in practice. Because a closure is assessed only on the totality of the evidence, the actual operation of the regime is properly before the court. Cameron, they cite Lilly. They cite Lilly again. The affidavit of Thelma Anderson, a member of the public who repeatedly sought to attend the trial, establishes that the regime operated more restrictively than its text provided, and that reasonable alternative was not merely overlooked, but affirmatively withdrawn. These facts compound the deficiencies apparent in the order's face. They do not supplant